Assalamualaikum warahmatullahi wabarakatuh. My name is Wan Uzma Afifah binti Wan Ismail and my metric number is 1251136. And today I will be presenting a comprehensive case analysis on Subashini anak perempuan Raja Singham against Saravanan anak lelaki Tan Gatorai 2008 to MLJ 147. This is a landmark federal court decision that stands at the heart of Malaysian constitutional law. It explores the delicate balance between the civil and Sharia legal system, particularly when a religious conversion affects a marriage originally contracted under civil law. Let's look at the background of the case. The appellant, Subashini, and the respondent, Saravanan, were married in 2001 under the Law Reform Marriage and Divorce Act 1976. In 2006, the husband converted to Islam. Shortly after, he also converted their eldest son to Islam without the wife's knowledge. The conflict began when the husband sought a dissolution of marriage and custody of the children in the Sharia court. In retaliation, the wife filed a divorce petition in the Civil High Court and applied for an interim injunction to stop her husband from proceeding in the Sharia court. The High Court refused the injunction, and the case eventually moved up to the Court of Appeal and finally to the Federal Court, which is the decision we are analysing today. So the objective of this presentation are to dissect three critical legal issues. First, we examine the sanctity of a civil marriage. Does it automatically dissolve when party converts to Islam? Second, we look at the jurisdictional conflict under Article 121 Clause 1A of the Federal Constitution. Can a civil court interfere with matters brought before a Sharia court? Third, we analyse the interpretation of Article 12 Clause 4 concerning the rights of a single parent to determine the religion of a minor child, often referred to as unilateral conversion. Now, let's move into the legal analysis, which is the core of this case. The Federal Court relied heavily on Section 51 of the LRA. The court clarified that a civil marriage does not cease to exist just because one spouse becomes a Muslim. It remains a valid civil obligation until a civil court judge says otherwise. However, the court also highlighted a strict procedure. Under Section 51, the non-converting spouse must wait for a 3-month cooling-off period after the conversion before filing for divorce. In this case, Subashini filed her petition before that period ended. Furthermore, on the issue of Article 121 Clause 1A, the Federal Court held that while the Civil Court has jurisdiction over the civil marriage, it does not have the power to stop a Muslim spouse from seeking a remedy in the Sharia court. This created a dual-track system where both courts were operating simultaneously on the same family unit. In the discussion section, we must address the controversial ruling on unilateral conversion. Justice Nick Hashim, in his judgment, interpreted the word parent in Article 12 Clause 4 of the Constitution in a literal and singular sense. He concluded that either the father or the mother could convert the child. This was a very heavy blow to the rights of the non-converting parents. From my perspective, this case illustrates the legal vacuum and limbo faced by families in Malaysia. The wife was unable to defend herself in the Sharia court because she had no local standby there as a non-Muslim. At the same time, the civil court felt restricted by Article 121 Clause 1A from providing her the full protection she sought. This case highlights a significant clash of jurisdiction that caused immense procedural hardship. Now, for my personal commentary on this case. First, I believe the court was too technical. By dismissing the case just because of the 3-month timing issue, the wife was denied immediate justice. Second, it shows a legal limbo. The wife was stuck because she could not go to the Sharia court, but the civil court also had its hands tied. Lastly, although the wife lost, this case was a turning point. It forced our legal system to change, leading to the better protection we have today in the Indira Gandhi case. This shows that the law must evolve to be fair to everyone. To conclude, the federal court dismissed the wife's appeal. The court held that her divorce petition was a nullity because it was filed prematurely. Even though the court recognized the civil court's jurisdiction, the technical error in timing cost her the case. However, the legacy of this case is profound. While the 2008 ruling allowed unilateral conversion, we must note that this specific principle was later overruled by the federal court in the 2018 Indira Gandhi case, which now requires the consent of both parents. In summary, Subhashini against Saravanan remains a cornerstone for law students to understand the complexities of our dual legal system and the importance of strict procedural compliance in litigation. I think that is all from me. Thank you.